What started as a simple online meetup quickly turned into a felony robbery case. The defendant admits arranging a marijuana deal through OfferUp, but instead of completing the transaction, prosecutors say he took the buyer's money and disappeared. Now he's standing before the judge, hoping to avoid prison with a plea agreement. But this hearing is about more than guilt. It's about whether the court believes he deserves a second chance. And before it's over, one unexpected legal decision will leave the entire courtroom thinking twice.
She met you on OfferUp to purchase marijuana from you. I don't know what people are thinking. You know, do you want to go to prison? Do you want to get arrested for nonsense? So why would you do this when you know you have a child?
Welcome to Judge Court Order
25 CR 006784 State versus Lafayette Pate. Could I have parties announced?
State. Christopher Ramos for the defense.
And are you Mr. Pate?
Yeah.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Pate, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yeah.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are.
All right, Mr. Pate, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
You're charged with robbery. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant the application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he is currently competent and was legally sane at the time of the offense?
I do.
Mr. Pate, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. There's to be restitution to the complainant of $125. Did you understand that to be your plea? Defense state?
Yes, Judge. Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 200 hours community service restitution, no contact with the complainant. The MRT course, anti-theft course, felony anti-theft course, and no possession of firearms, and a transfer to Dallas County. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Go to your exhibit number 1, including all attachments.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Have you spoken with the complainant?
I believe we have, Judge.
You may be excused. Thank you. How old are you?
23 now.
All right. Court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. What are you planning on doing with the rest of your life besides meeting people up on offer up for the purchase of marijuana and then taking their money and not delivering on the product? Other than that, what are you planning on doing with the rest of your life?
Get my CDL and further my barber career. Take care of my child or so.
I'm sorry, what?
Trying to get my CDL and further my barber career and just take care of my child now.
And how old is your child?
2 years.
All right. When this offense occurred, was your child on the planet?
Yeah.
All right. I guess waiting to be born. So why would you do this when you know you have a child?
I'm not sure now.
I don't know what people are thinking. You know, do you want to go to prison? Do you want to get arrested for nonsense? I don't know why people just can't get a job. Get a job. And I didn't know, when have they started doing marijuana sales on OfferUp? Is that something new? I've never used OfferUp, so I don't know. But the last time I have people who said they've done OfferUp, it's for, hey, you want to buy this motorcycle? You want to buy a piece of furniture? It's not marijuana. When you do OfferUp, do you just like put on OfferUp, you're selling marijuana? Well, I mean, that's what's in the stipulations. The stipulated evidence is she met you on OfferUp to purchase marijuana from you.
I think it's more of a messaging back and forth from the initial.
So I guess you just go and OfferUp, there's something I want to sell. And then somebody is, well, what do you want to sell? And then they message each other off.
Maybe coded 420 something. I don't know.
Oh, okay. Okay. You haven't been on OfferUp.
I haven't. I'm a defense attorney.
Yeah, I know. Yeah. All righty. So are you employed here or no? What do you do?
I'm a machine operator in the warehouse. I think in Dallas County.
Oh, in Dallas. Okay. All righty.
And his residence is in Dallas County, and his job is in Dallas County.
All right. We're going to do $1,000 fine. That'll be probated. Regular reporting by Zoom or in person. If you're drug tested today, will the results be? Oh, I mean, he wasn't with you.
He's speaking.
No, he's not speaking for you unless he was with you. So, I mean.
Yeah, cross-examination. Yeah. Sure. Could you told you signed the papers? Well, I would feel, no.
All right. So what are you going to be positive for?
THC.
And what else? All right.
I can offer that in meeting with him and dealing with him, he's very functional. A tap would be recommended, but I don't think he has. THC. I don't think he has a appendix issue.
Mm-hmm. And does your child live with you?
Not at the moment.
All right. So there's going to be regular reporting by Zoom or in person and no unsupervised contact with minors. There is to be, are any minors residing in your households?
Okay.
All right. I'm going to order no residing in households with minors. That will change after you start completing some of the things that are being required of you, okay? And the reason why I'm doing it is because newborns, well, children really shouldn't be around the smell of marijuana and other things. 5 years deferred adjudication, 200 hours of community service restitution. Once parenting classes are completed, which I'm ordering, 100 hours will be deducted. The remaining 100 hours will be deducted upon completion of the MRT. I'm not going to order the felony theft course. To me, no. There's to be no possession of firearms. Transfer to Dallas County. And if Dallas County does field visits, I'm going to want field visits 1 time per month for 6 months. And there's this restitution of $125, state,
Yes, Judge.
I don't want to order restitution for $125 because this is an illegal drug deal.
That was the terms of the offer, Judge, but we'll refer to the court on that.
All right. On offer up. Now, if I'm selling a piece of furniture on offer up, I expect people to pay for that. But if I'm selling drugs on offer up and somebody steals from me, I'm not even calling the police. Who calls the police on that?
You'd be surprised, Judge.
All right. Okay, so there is there should be proof of employment within 45 days. There should be no employment as a home health care provider or with minors. And probation, there should be regular UAs. And if you could make sure they test for levels. And he says that he has PTSD, so we can do a MIC evaluation out of custody. And I believe you all have some sort of trauma test that they can take or something. If you all can do that, and we'll see if there's some help that they can potentially give you. And what I can tell you, probation, this is sort of time for you with these conditions, and I know it seems a lot. That's why I'm giving you credit. Once you complete parenting classes, you don't have to do certain community service restitution hours. But this is a time for you to get your life in order, right? And so if there are issues, mental health issues or something else going on, just let probation know about it, because anytime you bring stuff like that to them, they're supposed to give you help that you need. And if they don't give it to you, you can come back here and I'll make sure it's done. All right, probation, anything else?
No, Judge.
Anything else you need from the court to be successful? All right, you're welcome. Did you review trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Right, because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And remember, because it was outside the agreement, but I guess that's something that you all sort of agreed to, even though it's outside the agreement, the no possession of firearms. Usually when you're on deferred adjudication, it's not a conviction, you can possess firearms. But because this was sort of your agreement, you're not allowed to possess any firearms. You understand?
No.
All right. And think about what you're doing before you do it. And always think, is this something my child would be proud of me? You know, to say, tell other children, that's my dad. And that's what you want. You want your child to be proud, to point you out to people, hey, that's my dad, and be happy to see you. And they can't if you're doing this type of thing. Okay. All right. Good luck to you. All right. You're welcome.
Thank you, Judge.
Court is calling, excuse me. Y'all are going to either need to whisper or stop talking behind the court reporter, because we're on the record. Court is calling 2020 CR 10218, State of Texas versus Jesse N.O. Can I have parties announced for the record for the state?
Allie Jackson.
Defense?
John Reitmeyer.
And are you Mr. N.O.?
Yes, Your Honor.
All right, this is a motion for a new trial. State, have you had a chance to review the motion?
Yes, Your Honor.
All right, defense, it's your motion.
Well, Judge, we filed a motion for new trial on this matter sometime well after the verdict. By dumb luck, really, I was speaking with another attorney, and he informed me that there was a previous disclosure from the state about one of the testifying witnesses, Dr. Kellogg. I had never seen that before, and I went through everything that we had on e-discovery. Did not see any disclosures that were made to me about Dr. Kellogg. And I was informed that what I saw, there was at least one, there should be more.
And what would this disclosure be?
I have it, Your Honor. I pulled it from the physical file. So it was in the physical file when we pulled it from archives, but I do concede that it was not uploaded into Veripic, so therefore it would not have been part of the discovery acknowledgement when I looked.
Okay.
So our contention is this disclosure about Dr. Kellogg relates to previous testimonies that could have proved useful to cross-examine her differently about other cases that she had testified in.
And I'm going to provide it to this judge.
All right. Would you all like to mark this and have this admitted into evidence?
We would, Your Honor. We're operating this defense one.
All right. Being offered into evidence for purposes of this hearing is defendant's exhibit number 1. It's a memorandum of disclosure as related to Dr. Nancy Kellogg. Is that correct, stating defense?
Yes, Your Honor.
Yes, Judge.
Okay. All right. Any other evidence, defense?
No, Judge, that's it. Just argument.
All right. The court will hear argument.
Judge, our argument is simply the state is required under 3914 of the Michael Morton Act to provide disclosures such as that to the defense prior to trial. We did not have a chance to look at it. We didn't know anything really about it. And since it's under the state's control and custody, we had no way of obtaining it. Our argument is that affected my client's rights, and we're asking for a new trial.
State.
Yes, Your Honor. I'm providing case law. It's going to be 353 Southwest 3D 797 from the Court of Criminal Appeals. And it just lays out the prongs that you look for in this case when it's going to be a motion for a new trial for a Brady. The first prong is that the state failed to disclose evidence regardless of prosecution's good or bad faith. We do concede that it was not turned over. But when you look in the law that kind of helps talk you through it, starting on page 11, part of that first prong is that it was not disclosed, but also that the defendant could not have accessed it from other sources. In this case, this is a well-known disclosure. It's been around for years. And the first thing that you see when you Google this witness, Dr. Nancy Kellogg, as you often do when you look at an expert witness, you see multiple articles that actually provide even more information than the disclosure, both on the first page. And then if you hit news, all of the articles that are listed are about this disclosure with more details. So that's the first prong. The second prong is that the withheld evidence is favorable. We concede that, Your Honor. This would be for purposes of cross-examination. So the second prong is met. I think the first prong is shaky, but finally the third prong that must be met is that the evidence is material and that there is a reasonable probability that had the evidence been disclosed, the outcome of the trial would have been different. Now, when looking at and evaluating whether or not the outcome would have been different, you look at the entirety of the testimony that came out during trial. In this case, Dr. Kellogg was not a fact witness. She did not prove any of the elements. All of the elements, like elemental testimony, came from the victim and came from the outcry witness, Sam Abrego. Dr. Kellogg's testimony was very limited because she did not perform the state exam, and she testified she did not perform it. She just observed it. She testified as to what a state exam was. That one was performed, that there were no physical findings, and that no physical evidence was taken. All she could say was that it doesn't go against what the victim was saying, but she also could not say it definitively happened. So her testimony was not material, and the ability to cross-examine her on this would not have changed any sort of defense. The defense was always, this did not happen. The victim's lying. And that was what the defense would still be, because here the evidence showed, and she conceded, well, I can't say definitively whether it showed or not. And being cross-examined on this would continue to show and show the same defense. I can't say whether this happened or not. So because of that, while it was not given over, going through the three prongs of what a Brady violation results in a new trial, we do not feel it has been met. So we would argue against a new trial.
All right. And the court will note in defendant's exhibit number 1, it does state that there was a study that was published in 2007 as it relates to any testimony that Dr. Nancy Kellogg had given. So am I correct in assuming that this disclosure has been around since 2007?
I believe it's been more since around 2013. If you look further in the disclosure, it says that in 2013, she gave an interview, or she spoke to the district attorney's office when they confronted her about that study, and it was in regards to the San Antonio 4, which is what all the articles reference to. And that's when she said, I'm aware of this new study, I'm aware of the new science, and my testimony would have been different if I were to do it now.
All right. So counsel, the state has handed over a case law regarding Pena. Do you need a chance to review that?
If I could, Judge.
All right. Because since we've already started the motion for new trial, the motion for new trial can be continued on a different date if you need time to
And Mr.
gather
Reitman,
case law.
Application of the law starts on page 11.
Yeah. So if you would like to review that and maybe come with your own case law, I can recall this.
Could we do that, Judge?
Sure. What is best for you?
Not tomorrow.
No.
I can make it work just almost any time.
All right. Do you all want to do it the week of April 1st or the week of April 8th?
Either of those work. The week of April 1st might be better for us, Judge. We might be less likely to be in trouble.
All right. So
That's fine. We can do that.
is Monday the 1st okay?
I can
Or either Tuesday the 2nd?
Tuesday is probably better for me, Judge.
All right. Ms. Ferguson, we're going to recall this for April 2nd. And then if you have any case law, if you could email it to the state.
Absolutely.
All right. Is there anything else?
Not right now, Judge.
All right, Mr. Inaho, we'll come back on April 2nd. So they're not going to transfer you. You'll be here on April 2nd, okay?
Yes, sir.